press the Let's Go Live button, which means we've got to wait for the stream to fire up all across the fruited plains of the internet. It is Friday. Black Friday, they say. Hopefully you're getting your shopping out, done, rocking and rolling, over with, finished. Let's make sure that we're alive and well before we kick it into high gear on this lovely day. We're on Facebook, we're on YouTube, we're on Odyssey, Rumble, Twitch. There's Twitch. And on Twitter, of course, and that means we can jump right into things. All right, somebody's saying, what am I going to mispronounce? Ghislaine Maxwell? That's how you pronounce it, Ghislaine. All right, let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group. We're located in Scottsdale, Arizona. And today we're talking about Ghislaine Maxwell. The trial is starting on Monday, and we've got some serious trial prep that we've got to get into. We're going to take a look at the final trial orders that came out from Judge Alison Nathan over on November 24th. And so we're getting in the final push, the final days, and it's going to be something that is going to be very exciting, I think. So we're going to take a look at that. It's scheduled to start November 29th. We're going to look at the final updates from the federal docket. We're going to review a New York Times article that came out and is providing new details about the final days of Jeffrey Epstein. And then there's some other interesting just Epstein news that we can talk about. Ghislaine Maxwell's brother is now out. There's just a lot to talk about. So we've got a lot of trial prep that we're going to get into. If you want to be a part of the show, the place to do that is over at watchingthewatchers.locals.com, where there's a form. It looks just like this. You can ask your questions here, and we'll get to those. We got 3 different segments today, 3 different topics. We also have segments and clips that are being lobbed over here on this channel, Robert Gruler ESQ Clips. So be sure to check that out if you're looking for a place where you can find these little, shareable segments that you can send over to friends or family. We certainly appreciate that. All right. Ghislaine Maxwell trial starting November 29th. Let's take a look at the parties. Over on the trial board, as we normally do, we know Ghislaine, Bobby Sternheim is her defense attorney. We have Damian Williams, U.S. Attorney for the Southern District of New York. And we have a number of different victims that we're going to learn a lot more about as this trial unfolds. We've got Judge Alison Nathan, going to hear a little bit more about her. A lot of orders came out from her. We know the jurors are going to be 18 strong. Only 12 of those are going to stick around. 6 of those are going to be booted out. This is how federal courts govern themselves. The prosecutors who are prosecuting Ghislaine Maxwell, we already have seen several of these people. I did a prior video about this, so you can dive in if you're looking at wanting more details about these people. But Laura Pomerantz is somebody who's prosecuting Ghislaine. We've got Maureen Comey, James Comey's daughter. Allison Moe, couldn't find a picture of her. Andrew Rohrbach. Damian Williams, probably not going to see much of him in court, but he is the total, the sort of chief U.S. attorney, the actual U.S. attorney out of the Southern District of New York. For the defense, we've got Bobby Sternheim, we've got Jeffrey Pagliuca, Laura Menninger. Both of these people are from the same law firm. I think they're based out of Denver. Then we've got Bobby Sternheim. She's out of New York. Christian Everdell, I also believe, is out of New York. And then Renato Stabile is a defense attorney who does focus groups and some of the technology stuff. And so they've got just a whopping team. We also have this, which I just started. So this thing is a little bit bare, but you'll see that we've got a number of different things that we are fleshing out. The prosecutors talked about them. Defense attorneys talked about them. We've got a number of government exhibits that we'll continue to flesh out as the government starts to unveil its exhibits. We're going to start to be able to catalog them and see exactly what they're talking about. We have a list of issues that are still pending. Really, these are, there's a lot of issues that are still going on. These are the 4 big ones that I have identified basically the last 2 weeks or so that we've been talking about this. Remember that we have been talking about this case a lot, off and on for about the last 18 months, but it's really sort of escalated and picked up speed, and there has been so much to cover. I've talked about this, that she's got these 5 different defense lawyers who are filing motions and slicing and dicing every single issue every which way, and so it's been a lot to sort of keep track of. But now what we're seeing is the synthesis of a lot of these issues. Trial is on Monday, and so we're going to need answers. Can this person testify? Can this piece of evidence come into court? Et cetera, et cetera. And so what we're seeing now in the final days are these issues. Government Exhibit 52. This is the black book that Jeffrey Epstein and Ghislaine Maxwell allegedly had at Epstein's property. And so the government wants to get this exhibit in. It's a black book with some contact information. They want that to come in. There's also been a battle. I talked a little bit about this with Viva when I was, I hopped on his channel before Thanksgiving. And we talked a little bit about this, but this was, if you're talking about transportation of minors, if you're talking about, trafficking in people under the age of 18, that means that one of the elements of the crime is that that individual is under the age of 18. And so you got to prove that. You can't just say, well, I was 16 at the time. You've got to show that individual actually had a birth certificate. And it's not just as easy as just, submitting a document into court. You've got to authenticate it. Who's the custodian of records? Lay the proper foundation in order to get that in. And so they're still fighting over that. Like I said, they're fighting over every single sliver they can. Expert witness testimony. We're going to talk a lot more about this today. And then the Epstein's Victim Compensation Fund. I don't have any updates on that on this video, but most of this we're talking about expert witness testimony. We're fleshing out the victims, as the prosecution calls them, or the accusers, as the defense calls them. And then we're going to see there's a lot of expert witnesses. So this branch is really, really going to be fleshed out pretty massively. So let's take a look now at the court docket. As a reminder, a lot of activity here. We can spend a lot of time mincing through all these different words. We're just going to cover a couple of the big topics today. First and foremost, up at the top, entry 500. We've got these various protective orders. And so we can basically skip over these protective orders, as we've talked about. Federal courts, not televised. You cannot rebroadcast any of the audio. So this is all that we've got. We can only go through the sketches. We can only go through the minute entries. And even the minute entries, even a lot of the documents that we're going to go through, they're all redacted. Huge pages, paragraphs, entirely blanked out. Can't see anything. And that's what we're talking about here when they're referencing these protective orders. They're saying, Judge, here's our proposed order. Here's our proposed redactions. And so a lot of this stuff is just being protected. We do get on 1124, we get two orders, which are going to detail some of the trial rules. And so we're going to read through both of these, not really long. Then we've got this last section here, a lot of conversation from 505 all the way to 509. Basically, all of this is battling over expert witnesses. And we're learning a little bit more about what these experts are going to come in and testify about. A lot of psychiatrists, a lot of psychologists, people who are going to come in and talk about memory and recall and creating memories and forgetting things and how things change and bias and perception and all sorts of, very, very interesting stuff. We went through some of the expert witnesses, I think, on a prior video, 1123, the day preceding the update, today's update. And so we'll take a look at that. And we're also going to see this issue, which is the Epstein Victims Compensation Fund issue. This is Jordana Feldman. And so this is this issue specifically about the compensation fund. The allegation here, the effort here is the defense wants access to documents that had to do with people allegedly abused by Epstein, submitting a request for compensation from this Victims Compensation Fund. And so we're going to break that down a little bit further as well. The first document we'll jump into is the trial order. So you can see this was filed the day before Thanksgiving, 11/24. Order. This is from Judge Alison Nathan, U.S. of America versus Ghislaine Maxwell. It says, as noted in the prior court order, trial in this case going to commence November 29th, 2021. Going to be happen in courtroom 318, United States District Court for the Southern District of New York, Thurgood Marshall Courthouse. Gives you the address. In accordance with its prior order, the court will ensure access for alleged victims and members of the defendant's family. So that's about it. Federal rules of criminal procedure prohibit the broadcasting of federal judicial criminal proceedings from the courtroom. And they link you to that. However, as indicated below, consistent with these protocols, the court will facilitate, they say, substantial public and press access at the courthouse. First, consistent with the distancing requirement, a number of pool reporters and members of the public will be permitted in the courtroom proper as managed by the executive office. So, can actually go in there, and members of the pool reporters will be there. I obviously cannot be there. I'm in Arizona, but doesn't preclude people in New York from going there. Second, press will be able to access the trial in a dedicated overflow courtroom. Questions about press access direct towards these individuals. Third, members of the public will also be able to access the trial in overflow courtrooms. The overflow courtrooms will have live video and audio feeds of the proceeding. So, live video and audio, but can't be rebroadcast. pursuant to these rules. So you can just sit in the overflow room and just watch. You can tweet about it, you can write about it, but you can't broadcast it outside of those overflow rooms. There will be substantial seating capacity available. If capacity is reached, no additional persons will be admitted. If you have any questions, call that number. Per the COVID policy, anybody who appears there must get their temperature taken, have a questionnaire completed, wear a mask, 100.4 degree temperature, so on and so forth. Signed by Judge Alison Nathan. You can see her here. So, a lot of reporters will be there, but there's sort of a filter. So anything that we get, anything that lands up on Twitter or on, the New York Times, it's all going to be filtered through whoever's in that courtroom. So we'll see, if there are people in New York. I know that Good Logic, Joe Neerman, was actually saying that he might take a train down over there, which I fully support, Joe, if you do that, because it would be good to see some people, firsthand accounts about what's really going on there without it being filtered through journalists, so-called journalists. So that's what's happening. Now, we were talking about this Epstein Victims Compensation Fund. This is a very interesting thing that existed that I didn't know much about. But Jeffrey Epstein was so abusive that he had to set up an entire organization to help him process these claims. So many people were going to be suing him civilly, and so many people were, potentially going to be filing or making additional criminal reports, that they set up an entire compensation program. And they even have a website for it. You can go and find it. Here's what it looks like if you navigate over there. It's EpsteinVCP.com. And so it's the Epstein Victims Compensation Program. So if you go over there, you'll see Epstein's Victims Compensation Program announces the conclusion of the claims process. They're done. No more money going out. But approximately $125 million has been awarded to eligible claimants. Woo, buddy, that's a lot of money. $125 million. That is a lot of abuse, isn't it? And paid that out. Claim filing deadline, that expired on March 25th. So if you were an abusee, if you got abused, you're out of time. Effective June 25th, 2020, the compensation program is going to accept claims. It's voluntary, non-adversarial. We operate independently of the Epstein estate. Talks about Attorney General, Virgin Island, blah, blah, blah. We get a little bit more detail about what this program entails. Epstein estate can't modify or reject anything. The program is confidential. The program is purely voluntary. No individuals required to participate. Individuals who have filed a lawsuit or have otherwise been identified as a victim are eligible to participate in the program. If you have not previously filed a lawsuit or a legal action or a claim, you may be eligible to participate. So you see that? You see how this works here? Individuals who have already filed a lawsuit or a legal action or a claim, you are eligible to participate in the program. So if you have filed something, if you say that I have been abused by Epstein, you're automatically eligible. But if you have not previously filed a lawsuit or any claim, you only may be eligible. So you're sort of incentivized, aren't you, to then go make a claim, to file a lawsuit or to contact the police, because then you're automatically eligible. You're not may eligible. If you are a may eligible person, if you've not already filed a lawsuit or done anything like that, well, you can actually just go and register on this website. Give us the nature of your claim. You can provide your information, give us a summary description, what abuse took place, give us the dates and the location of the abuse on or before the 21st, February 2021. We have somebody named Marcy A. Hamilton. She's an abuse expert. She serves as a consultant, so she's going to review your claim. They're going to have a fair and efficient resolution of the claims process. We have effective deadlines. So that's the actual program. And then as we saw in August, they told us that they're done with these claims because $125 million has been paid out. $125 million out to 150 eligible claimants. So the average payout is probably what? 150 eligible claimants divided by 125 million, just under $1 million apiece, 800,000. 92% accepted their offers. Compensation program paid out over 121 million. The number of claims submitted was 225, far exceeded original expectations that 100 claims would be filed, so 225 claims. We get some quotes consistent with the governing protocol. We're going to preserve claimants, blah, blah, blah. Very proud of what we've accomplished with this program. Many victims have endured pain because of Epstein. My hope is the program gave the victims a meaningful measure of justice and a step the path towards healing. Would $800,000, $900,000 paper over all of your sexual abuse? I doubt it, personally, but maybe it did. We have another document now. So that was the Epstein's victims compensation fund. So let's talk about that issue specifically. The defense wants information about that process. We just went through it. We saw that if you're a claimant, a potential claimant, if you received abuse from Epstein or Maxwell or anybody sort of in his purview, very simple. If you have filed a lawsuit, if you filed a criminal claim, then you're automatically eligible. Don't even need to register. Just send us a copy of the documents and we'll make sure that we process your claim. But if you have not done that already, if you've not filed a lawsuit or not pursued any criminal charges, register here. Fill out this form. It can all be submitted and then we'll think about it. And so what the defense wants is all of that information. They want the form. They want the summary. They want the payouts. They want to know because we just heard there were 225 different individuals, presumably women, who all made these claims and something like 150 of them got paid out. That's a lot of people. What if the same people that are a part of that 150 claimants who got income, who received compensation, what if those are the accusers? Is there overlap there? Because if the accusers got paid $900,000 and they had a strong incentive to file a claim or to file a criminal charge, in order to automatically be put into the program, you can see how that might cause people to be biased. Somebody might want $1 million or however much they think their friend got, and they say, well, did you file a criminal claim against Ghislaine Maxwell? And they'll say, no, I didn't. Well, you better. Otherwise, you're not going to get paid, is what the defense attorneys are going to argue. And so you can see how that might create some bias. The defense attorneys, they want that. They want to see what's going on there. Give us access to this entire compensation program is really what they want. And so the court came out, Judge Alison Nathan again, and says, previously had granted a subpoena that authorizes them to get some of this stuff. Defense filed for a subpoena. Judge said, yep, you're entitled to get it. So then the compensation fund provided a lot of it back over to the court. You can see it says here, the court is in receipt of these documents. The court's also in receipt of a protective order to hide some of these documents, and we're going to follow that order. Consistent with the order, the court determines that the parties may review the materials under the provisions of the order, and the administrator of the Epstein Victims Compensation Program is ordered now to produce the materials contained in the production as soon as no later than November 24th. So what does this mean? It means the judge has gotten sort of a preliminary overview of what the documents contain, what the documents from the Epstein Victims Compensation Fund contain, and we can see a little bit of what it might be. So this is from Smith Villazor. Now, this is from Patrick Smith. Patrick Smith is representing Jordana Feldman. She is the administrator of the Epstein Victims Compensation Program. So now the subpoena gets granted. The defense says, we want access to all that stuff. They ask for a subpoena. They say, Judge, they're not going to give it to us. Can you order them to give it to us? Judge says, yeah, totally. It's absolutely relevant. So they go, perfect. We got an order from the court. Ms. Feldman and Epstein's Victims Fund, here's the order. Give us everything you got. So now Jordana Feldman says, okay, lawyer, can you tell them that this is going to be like a lot of work? And the lawyer says, yeah, we can do that. So they write back into the court and they say, listen, we're writing regarding your order. You denied our motion to stop this subpoena, and you're ordering the production of the documents on November 24th at noon. Ms. Feldman, the lawyer says, intends to comply with the court's order, and we are going to produce these documents. However, given the volume of the materials and the steps necessary to ensure that these documents are within the scope of the subpoena, it's not going to be possible to produce all these materials by noon tomorrow. We understand that the volume of potentially responsive material is 6,000 to 7,000 pages. We note that the original return date for the subpoena was November 29th at 8:30. They say, we intend to produce by noon tomorrow, redacted, 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 redacted. Don't know what that is, but it also says we intend to produce remaining responsive documents as soon as possible thereafter. We request until November 29th to be able to do that. And the court's probably going to say, okay, well, 7,000 pages. Now that's when trial starts. So it's kind of the last minute, isn't it? We request until November 29th at 8:30 a.m. the moment we swear the jury in and we start with opening arguments. So cutting it close to the last minute. Now, we talked about that protective order. So this is one of those protective orders I mentioned. You can see here the parties are jointly submitting the attached proposed protective order. So they just give us a little bit of basis for why this information might be problematic. You know, it could affect the privacy or the confidentiality of individuals, could risk prejudicial pretrial publicity, blah, blah, blah. So this is why they don't want it to be published. They say all of this is going to be deemed confidential, highly confidential. They send that over to the judge. And then the judge basically just says, sounds good. We're going to blank everything out, not even going to worry about it. So we're going to see what ends up happening with these documents. The judge is probably going to give them, up until the last minute, because it's a lot of documents. And then it's all going to come skidding in here, maybe over the weekend, maybe today, tomorrow, we'll see. And then the defense team is going to have to comb through all of those documents and see if they can tease out anything that might apply or be pertinent in this case. We also have another issue in the Maxwell case. We can see here the government is trying to throw out Ghislaine Maxwell's expert witnesses. You can see here, the government filed a memorandum of law in support of its motion in limine. And remember, a motion in limine is a motion to preclude something or to limit something from happening. They want to stop something from coming into courts. Here, very obvious, very easy. They want to stop expert witnesses from coming in. And it looks like there's 6 of them. We have Ryan Hall, number 1. They don't want him. They don't want Bennett Gershman. They don't want Robert Kelso, John Lopez, Gerald Laporte, or Jennifer Nasso. And so they filed this 11/24, the day before Thanksgiving. The government is saying, Judge, you have to stop these expert witnesses from coming in and testifying. Trial is starting on Monday, Judge. The defense just told us they've got these 6 people that they're going to have come in and testify, and we think that you should limit that. And they're filing it right before trial, which is not unusual. They're talking about a couple of of course, 6 of those expert witnesses. We are not going to go through all 6 of them. We're going to spend our time talking about Ryan Hall. Ryan Hall is sort of the big one, I think, that the government is mostly concerned about. And you can see this is a 15-page document, but this actually came from the defense disclosure. So the defense communicated this back to the prosecution previously. And so it's not much, but we have a little blurb. It says, redacted, 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 redacted. Talking about, obviously, a victim or an accuser in this case. So they give us a sentence. This is what we're talking about. So they say Dr. Hall's curriculum is attached Exhibit D. His report is attached as Exhibit E. Attached as Exhibit F is a list of material reviewed by Dr. Hall. He's an expert in the field of forensic psychiatry, and he's going to offer opinions as such. He will offer opinions and diagnoses contained in his report, the bases for those opinions, and the significance of the diagnoses and opinions. And then we get three lines of redactions. So that's who we're talking about, Dr. Hall. Don't know much more about him because a lot of it's been redacted. But the government wants to stop him from testifying. And you're going to see that most of their motion, most of their memorandum is in support of stopping Dr. Hall. You can see that it's 28 pages, and basically pages 4 through 15, so almost half of it, are all focused on Dr. Ryan Hall. Then we get page 20, 21, 20, 21, maybe 22, maybe for Gershman. And then we get 22 through 24 for Rob Kelso, John Lopez. But the crux of this is all about this guy, Dr. Hall. And you can see it says the court should stop testimony of Dr. Hall. They say his opinions are not independently admissible. Any undisclosed significance of his opinions is inadmissible. His fact testimony is inadmissible, blah, blah, blah. So Dr. Hall is the big guy. Preliminary statement, once again, coming from the prosecution. They're saying, Judge, stop these people from testifying. Why? The defendant, Ghislaine, has notified the government that she plans to call 6 additional experts. One of them, Dr. Ryan Hall. Redacted. Redacted, redacted, and drafted a lengthy report containing a large recitation of hearsay, attributing some, but not all, of blank, blank, blank to blank. The hell are they talking about? Bennett Gershman is a purported expert on prosecutorial misconduct. Neither of these issues is relevant at trial, and both experts should be precluded. You see here it says another. Bennett Gershman is a purported expert on prosecutorial misconduct. So are they talking about Dr. Ryan Hall, talking about prosecutorial misconduct? Interesting. The defendant has failed to provide adequate notice as to the 4 remaining experts. Instead of describing their opinions as required by the rule, they notice identified on topics. The government is therefore not able to impose a Daubert challenge. So they're complaining about notice. Now, let's take a look at this next paragraph, this next page. So I want to show you what we're looking at here because this is what it looks like. And this isn't even bad. So this is the government's memorandum. And I'm going to skip through a bunch of it, but this is one page. This is page 4. Here is their argument as to why they should not allow him to come in. They say Dr. Ryan Hall is a psychiatrist. He frequently testifies as an expert witness. Redacted, redacted, redacted. According to the notice, he's going to offer opinion and diagnoses contained in his blank report, the basis for those opinions, and the significance of the diagnoses and the opinions. They say they should exclude his testimony. Why? As he disclosed in his opinions, it has no relevance and none bears on the facts of this case or minor victims for credibility. So we've got minor victim 4 we've got to add to our victims list. Any basis for those opinions is therefore irrelevant. Similarly, absence, they have no bearing here. They talk about none of those opinions bear on the facts of this case or a witness's credibility. Their introduction would only serve to, confuse the jury about something else. Dr. Hall's testimony, now watch this. Watch this next page. We're going to get a lot out of this one. Watch this. Dr. Hall's proffered fact testimony should also be excluded. Much of it would constitute hearsay. And then we have Dr. Hall's opinions blank are irrelevant. The entire page is redacted. So, yeah, that's what we've got. Then we get another one here. And basically, most of the rest of the document is just all redactions. They say Dr. Hall's conclusions on this issue should thus be excluded because it's going to confuse the issues. All this is just case law stuff, referencing the Second Circuit, U.S. Supreme Court, Second Circuit, 2006, 1995. So they're not going to need to redact that because it doesn't say anything other than publicly available case law. Then we have over here, page 7, lots to glean here. Well, maybe we can go over to page 8. No, that's page 8. Anything there? No, nothing there. Anything on page 9? No, nothing there. All right, so this trial is going to be great. Here we've got other bases for why this stuff is not supposed to be admissible. And you can see these are just broad general arguments. We're not going to spend a lot of time on this because we can't see anything. The basis of Dr. Hall's opinions are not independently admissible. According to the defendant's expert notice, she also seeks to elicit the bases for the opinions of Dr. Hall's blank report. Because those opinions themselves should not be admitted for the reasons just discussed, there's no grounds to admit their basis. All, again, redacted. Talking more again about minor victim 4, more minor victim 4 out-of-court statements. And you can see page 13, redacted. We get a little paragraph about Bennett Gershman. Again, talking, prosecutors say this is irrelevant. And it's going to be the same argument, so we can fly through the rest of this. Even if testimony was not barred, they're talking about having inadequate notice. We have a little blurb, as I mentioned, about these two defendants, or experts. Let's see who these people are. So we've got Robert Kelso. He's a computer forensics specialist. The defense called him. He's going to testify about user data that's associated with certain devices, photographs. He may also testify generally about computer forensic principles associated with the creation of documents, storage, and retrieval of digital documents. May also testify in rebuttal to any testimony offered by the government through Stephen Flatley. So he's a computer forensics guy. And then we have John Lopez, who is a financial investigator. Interesting. He's going to discuss various transfers of funds that are reflected in the financial records and explain the information regarding those transfers. So they've got multiple experts that they want to boot out, including computer forensics, financial investigators. We've got Gershman. We've got Hall. And they're asking that they all be precluded. You can see this was signed off on by all 4 prosecutors. For these reasons, they want to preclude any expert testimony. Wow, okay. All right, so that got filed. Now, the defense fired right back. And they are, of course, opposing that. So the government wants to stop them all from testifying. The defense responded right away, and they say, no. You can see this was signed off on by Pagliuca and Menninger, Christian Everdell, Bobby Sternheim. It's direct response. And as we talked about, they're also addressing Dr. Hall. We get some factual background here. There's a little bit more interesting stuff here, so we can read through this, but it says factual background about Dr. Hall. The government's motion's not breaking it's not a challenge under the rule, not an appropriate challenge. And then we get some of the constitutional objections. If you don't let her call her own expert, that's a violation of the Constitution. It's not overly prejudicial under Rule 403. In other words, bringing this expert is not going to do more harm than good. And again, it's 21 pages. Let's take a look. Ghislaine Maxwell now responds. The government claims to bring its motion under the rules. They're not doing that. Instead, it's training its sights almost exclusively on Dr. Hall. The government says that the opinions of Ms. Maxwell's experts are either irrelevant or unfairly prejudicial. The court can deny the motion for the simple reason the government is proceeding under the wrong rule at the wrong time. Ms. Maxwell's expert witnesses are qualified because their opinions are reliable. Their testimony is admissible under Rule 702. As for relevance and prejudice, the government's arguments are both unfounded and premature. Finally, if the government is entitled to additional notice, Maxwell will provide it for the reasons. These guys are just, it's too funny. The reason it's funny is because they're just sort of laughing at the prosecutor. Yeah, if you're entitled to more, we know the rules better than you. You're filing under the wrong rule at the wrong time. You can't bring it under 702. It's not a 702 challenge. You're not entitled to any notice either. If you're entitled to notice, we'll tell you when you're entitled to it. So they say, for the reasons, therefore, the exclusion of Ms. Maxwell expert witnesses should not be allowed. All right. Here's what they say. Argument. Although the government offers some types of challenge, however conclusory, to all of expert witnesses, the true target of their motion is Dr. Ryan Hall. Dr. Hall, he's eminently qualified. He's an MD. He conducted an independent medical examination of redacted. Don't know who it is. His 108-page detailed report is based on extensive review of documentary evidence, medical records, court files, and a 6.5-hour interview with blank. Reliability of Dr. Hall's report is unquestioned and unquestionable. From the government's perspective, however, the report's conclusions are highly problematic for its case, which is why the government is so eager to preclude Dr. Hall's testimony. So what they're saying here, the defense is saying, yeah, the government is trying to preclude all 6 of our experts. They really only want the one guy, Dr. Hall. Why? Dr. Hall did a 6.5 interview with so-and-so, whoever that is, and he wrote a 108-page report about it. And it's pretty damn bad for your case, Mr. Government. It's so problematic that you're trying to stop him from even coming in and testifying in the first place. Dr. Hall, this report is so damning. Dr. Hall says in his report, he talks about all this stuff. Look at this page. That's going to be, government's in big trouble now. In his report, Dr. Hall documents 3 paragraphs of redacted. We also have some more factual background here. Accuser number 4, you see how the defense calls it accuser, not victim. Accuser 4 blank is the named victim in several of the counts against Ms. Maxwell, including conspiracy. Government claims she was abused by Epstein from 01 to 04. More redactions. So-and-so, Dr. Hall reviewed blank records and interviewed blank over the course of 6.5 hours. He produced a 108-page report, which the government produced to Ms. Maxwell, recognizing its relevance and its exculpatory value. Ooh. So Dr. Hall then sounds like did what maybe was not an actual defense expert at the time, because the government got the report and they produced it to the defense team, recognizing its relevance and its exculpatory value. In other words, if they did not give that over to the defense and the defense found out about it, that's a Brady violation. Their report is so problematic for their case, they had to disclose it. If they didn't, there'd be sanctions and ramifications for that. So now that they have disclosed it, now they're trying to say, well, Dr. Hall, it's not relevant. As is relevant to the government's motion to preclude Dr. Hall from testifying, the report addresses 2 areas that are essential to Ms. Maxwell's defense in this case. Is this going to be juicy or what? No, it's redacted. Can't see any of that either. 2 areas that are essential to Ms. Maxwell's defense, and we don't even get to see what they are. Then we get into the constitutional arguments. So they can show us this because we've already seen this. We already know what all this is. Excluding Dr. Hall's expert opinions, it's going to deprive Ms. Maxwell of her constitutional rights to confrontation and to present a defense. Standard stuff here. What good is a trial if you can't present any of your evidence or any of your theories or use any of your expert witnesses to come in and testify? Pretty standard constitutional stuff there. So they talk about this. They say the defense is arguing, again, Pagliuca, Everdell, Sternheim, Menninger. The court should reject the government's remaining arguments about Kelso, John Lopez, Laporte, etc. Really, only 2 responses are in order. Ms. Maxwell's notices are as thorough as the government's notices were, so the government can hardly complain about being in the dark. But if this court concludes otherwise, the remedy is for Ms. Maxwell to provide additional notice, not exclusion. Moreover, as the government concedes is permissible, Ms. Maxwell has endorsed these witnesses in part out of an abundance of caution and in part because Ms. Maxwell still doesn't know what evidence the government will actually admit at trial. If the testimony from these witnesses is not relevant, Ms. Maxwell will not call them. But if the government evidence makes their testimony relevant, Ms. Maxwell can always provide additional notice if ordered to do so by the court. Therefore, court should deny this motion. And that was dated back on November 19th, finally hit the court docket, and then we got to see it. So let's take a quick pause and see if there are any questions or comments that have come in from our friends over at watchingthewatchers.locals.com, and then we'll just jump into the next segment. Couple questions here. Looks like don't know what that question was for. Thunder7 says, the names of the people involved will shock those who haven't a clue. Bail her out and put her out in a safe house before she dies. Only she knows who's really involved, and I hope someone brings them all down. She has no choice if she wants to negotiate some kind of a deal to maybe serve a life sentence in prison where the elites go, as she can't handle real prison. Trade-off would be worth it to go arrest all those who abused the trafficked minors. From Thunder7, I'm not sure that they're going to cut her a deal. Roybot says, has anyone explained how Epstein started his massive wealth? I believe that being a financier requires a lot of capital. Where did all that capital come from? It's a good question there, Roybot. A lot of people are asking that as well, no doubt. All right, and so we're going to carry on. Let's see what else we've got. Our next segment is going to be talking about this very interesting New York Times article. Epstein killed himself? A lot of people have a lot of questions about that. I'm not so sure. Neither is the New York Times. In fact, they came out with this article November 23rd, right on the verge of the Ghislaine Maxwell trial. That starts Monday, November 29th. They posted November 23rd. They say, Epstein's final days, celebrity reminiscing and a running toilet. Newly released records show the disgraced financier living a mundane existence before his suicide. And it spun deceptions until the very end. So we're going to go through this article. Pretty interesting. They've got some new documents that they just recently released, and it turns out that even though Epstein killed himself, he gave no indication he had that proclivity whatsoever. In fact, he was saying things were pretty good and he wouldn't kill himself. So we got to go through this, don't we? The disgraced financier jailed in Manhattan found unconscious on his floor in his cell morning July 29th, stripped of his bedsheet that was tied around his bruised neck. In hours and days that followed that suicide attempt, Epstein would be claiming to living a wonderful life, even as he sat on suicide watch. Says, I have no intention of killing myself, he told a jailhouse psychologist. According to Bureau of Prison documents that have not previously been made public, he was, quote, a coward and did not like pain. Says, quote, I would not do that to myself. 2 weeks later, he did. Died in his cell August 10th. Out of the Metro Correctional Center. Hung himself with a bedsheet, according to the medical examiner. Okay. After a life of manipulation, Epstein created illusions until the very end, deceived correctional officers, counselors, and specially trained inmates that were assigned to monitor him around the clock. More than 2,000 pages of documents came out through a FOIA request, Freedom of Information Act lawsuit. Detailed notes and reports show that during his 36 days of detention show how he repeatedly assured them that he had much to live for, while also hinting that he was increasingly despondent. Clues prompted too little action by jail and officials who made the mistake after mistake leading up to his death, the records reveal. Beyond the legal and administrative matters, the collection records provides the most intimate and detailed look yet at his final days, and offers something often missing from public accounts: his voice. Past many days closed in a conference room, in conversations with psychologists and other inmates, he spoke of his interest in physics and mathematics, reminisced about celebrities, talked about his difficulty sleeping, dehydration, and numbness. Here's a document. While in prison, there's a clinical intervention report that says, quote, inmate Epstein was also upset about wearing an orange jumpsuit and being treated, quote, like a bad guy when he did not do anything wrong in the prison. Custody and security concerns were addressed with inmate Epstein, including why he has to wear his orange jumpsuit due to his being housed in SHU. Here's another clipping, sensitive but unclassified. So this is for Jeffrey Edward Epstein, date of birth 1/20/1953. This is a document that comes out of the Bureau of Prisons. This is their clinical intervention psychology services document. So specifically, they say the focus of this session was inmate Epstein was seen for his psychological observation follow-up in the attorney conference this afternoon. We get an opinion on him. Inmate Epstein reported he's consulting with his attorney most of the day. Same thing Maxwell's been doing. He elucidated concerns about incarceration, but not receiving his property, feeling cold in his cell, not receiving his colas, not having enough water in the attorney conference, desire to recreate an SHU, upset about wearing the orange jumpsuit, being treated like a bad guy, did not do anything wrong in the prison. Custody and security concerns were addressed with him about why he has to wear that. He requested to be placed in a brown uniform during his legal visits. He was told his concerns would be addressed. Then we get a couple paragraphs of redactions. Didn't sleep well last night, continues to deny any suicidal ideation, intention, or plan. Did not appear to be in distress. No suicidal ideations. Provided with brief supportive interventions, CBT-based interventions, cognitive behavioral therapy. He was receptive to these interventions, psychoeducation regarding additional coping strategies. So he's getting some treatment in there. He was educated about routine and emergency procedures, contacting psychology staff, reminded of the self-help books and audio tapes. He will be seen next week after the bail hearing to talk about his stability. So that was back on January. No, that's his date of birth. When did this come? Okay, 7/11/2019 is when this document came out. No suicidal ideations, not sleeping well, doesn't like the orange jumpsuit. Brown would be preferable. But that was on 7/11, and then on August 10th, 1 month later, he's dead. Okay. Epstein once rubbed shoulders with politicians. The newly obtained records offer no support to the explosion of conspiracy theories that his death was not a suicide. They shed no light on questions raised by his brother and one of his lawyers that he might have been assisted in killing himself, but they do paint a picture of incompetence and sloppiness within the Bureau of Prisons. An intake screening form erroneously described Mr. Epstein as a black male, which he was not. He was a white guy, and indicated he had no prior sex offenses, even though he was a registered sex offender. Few phone calls were not recorded, not logged, violation of jail policy. The night he killed himself, Epstein lied to jail officials and said he wanted to phone his mother, who was long dead, instead called his girlfriend. Jail personnel left him alone in his cell that night, despite an explicit directive that he be assigned a cellmate. Here is what it looked like inside the cell. So you can see the orange garbs all over the place. Presumably, you can see this orange garb wrapped around the ladder of the bunk. The allegation was that he was able to wrap those orange cloths around his neck and then sort of lean forward and hang himself. 2 days after the suicide, William Barr, U.S. Attorney General, said there were serious irregularities, but didn't elaborate. Later blamed a, quote, perfect storm of screw-ups. Okay. 15-page psychological reconstruction of his death was compiled a few weeks later. We have some of that. We'll go through it. Times obtained materials after suing the Bureau of Prisons, which had repeatedly rejected its public records requests. As part of the settlement, agency agreed to turn over internal memos and emails, visitor logs, handwritten notes from inmates, and the psychological reconstruction of Epstein's death. Many documents heavily redacted. Let's see what we've got here. Here's a picture of Epstein. He was arrested Saturday, July 6th. His detention detained there. Indictment charged him with many different offenses. He was originally put in general population. Was determined to be high profile. Let's see here. We've got some documents here. Okay. At 2030, Epstein is talking about business. And then we have another log at 2045. Epstein is lying down. Then at 20, we have a time log. So Jim Epstein is talking about business and investing. We've got Epstein is discussing business and life lessons. At 21:30, Epstein is lying down again. Then at 21:45, Epstein is sleeping. So somebody was keeping log of him. His suicide left many unanswered questions about his life. New York Times obtained more than 2,000 pages of these records. Also talked about being a coward, said he did not like pain, and his Jewish faith did not permit suicide. Oh, another nice little hint there. Adamantly denied he was suicidal, according to Daniel Ivory. She's reporting over at New York Times. Early in his stay at the jail, Epstein greeted one of his psychological observers while he was eating breakfast with a prison-issued paper spoon. His reference to it seemed to make light of the fact that others were worried he would harm himself. Says, "I have my paper spoon here." Kind of joking and making light of the situation. There's a quote from Epstein, says that he said, "I have to trust you if you want to trust me." Epstein expressed displeasure to a member of the psychology department that his jailers were not paying attention to his complaints about his living conditions. Among his concerns, the toilet ran, his cell was dirty, and the orange prison garb made others treat him like, quote, a bad guy. Apparently, Epstein, in his own words, said, quote, "It would be crazy to take my life." Even as he was on suicide watch and facing daunting legal challenges, Epstein at times suggested he had too much to live for outside of jail. He discussed his celebrity friends, though their names don't appear in the documents, his investments, and the escort business. So even in jail, this rotten person is like, well, no, I've got a whole escort business outside. Plus the celebs love me. In conversations with his minders, Epstein seemed to stick to subjects that would convey the impression he was approachable, yet well-connected and successful. An inmate wrote at 8 o'clock one evening, said, "Epstein and I are talking about the escort business. We're talking about arbitrage." 30 minutes more, Epstein talking about celebs. In another entry, inmate noted that he and Epstein were talking about driving taxis in New York. They both drove. Throughout it all, Epstein remained curious about his surroundings. On one of the first evenings, he asked an inmate whose name was redacted about the kind of crazy things he'd seen in jail. Epstein talked with an inmate for several hours about prison life and etiquette. And then at 2:35 a.m., the inmate noted, "Class is over." Epstein was asleep in 10 minutes. We have some more documents. It says that being alive is fun. And so we saw this, previously. One psychologist wrote that he was, quote, future-oriented. Described himself as a banker with a big business. Said that being alive is fun. Denied having sexually abused anyone, said he would have a renewed bail hearing next week where he believed he would be released. So why does a guy with a bail hearing who thinks he's going to be released kill himself? She concluded that suicide watch was not warranted, but that out of an abundance of caution, he should remain on psychological observation. In the weeks before his death, he made statements that he was a, quote, a coward, had difficulty adapting to his diminished circumstances, also frequently referenced poor sleep, inability to tolerate the noise of the prison. That was from a psychological reconstruction. We have a whole massive document. I just kind of want to show you this briefly. I think this is 18 pages, I believe. We're not going to go through it all. You can see up here in the top left that this is page 281. So just tons of documents. And this is stamped off on the U.S. Department of Justice, Federal Bureau of Prisons, stamped September 17, 2019. Memorandum for J. Ray Ormond from Hugh Hewitts, the Assistant Director, Reentry Services, and this is the psychological reconstruction of Jeffrey Epstein. Housed in New York, sex offender treatment, distribution of this is limited. Don't share this. He comes in within 60 days. All right, we get some people who are involved, number of different names who get copied on this. This is an interim report about the inmate death. They're reconstructing what's going on in his mind. How did this whole thing happen? Jeffrey Epstein. Background, 66 years old, white male. Different people were on the team. All their names have been redacted. They all worked on this case. Social history. Epstein did not have a PSR. It's called a pre-sentence report. So the follow was gathered from available documents. Grew up middle-class family, one brother, early promotion in 2 grades. He was graduated from Lafayette High School. Age of 16, attended Cooper Union, private school, Upper East Side of Manhattan until 1974. Dismissed 1976, inadequate development as a teacher. Number of positions in the financial industry to include a position as a limited partner at Bear Stearns until he was dismissed for unknown policy violations in 1981. Also worked as a financial consultant, founded at least 2 separate companies. 2 significant periods of employment. The first was his position as a consultant with Redacted in the late 1980s. Redacted was described as his first mentor. Redacted was later convicted and incarcerated for running a large Ponzi scheme. He implicated Mr. Epstein in fraudulently diverting company funds for his own personal use. Years later, Blank, Epstein's sole client at J. Epstein & Company, granted him power of attorney over his affairs. Despite being identified as Blank, mentee, Mr. Epstein again accused of misappropriated funds, more than $46 million. These large sums were the seed money that Mr. Epstein used to establish his considerable fortune. These events are indicative of his highly regarded intelligence and his charismatic personality. So Epstein sort of finagles his way into somebody's money, takes it all, and that's what he uses for the rest of his fortune. Legal history, long history of adult criminal charges, had a non-prosecution agreement, pled guilty to that, solicitation of prostitution, sentenced to 30 months, 18 months of incarceration, 12 months of probation, mandated to register as a sex offender, served 13 of his 18-month and then successfully completed 12 months of probation. Unclear whether he followed any of the rules thereafter. Formally charged with additional, bad charges involving underage individuals. 37 to pay decision in order. And you can see institutional history. New Jersey, healthcare and personality description. He also had continuous positive airway pressure, CPAP machine to help him sleep. We get a little bit of mental history, chief psychologist here. He was removed from suicide watch on July 24th after 31 hours, remained in a suicide watch cell. Then he was removed from psychological operation at 8:15 on July 30th. Attended court hearing on July 31st. And then saw a counselor, suicide risk not warranted. So they took him off suicide watch. We get a detailed description of the scene. They were serving breakfast, tried to use a defibrillator. Conclusions and recommendations. A general appreciation of risk factors for suicide is more appropriate. He was high profile. He was a pretrial detainee. A lot of charisma, a lot of charm. He appeared to cultivate a large network. So we've got some big recommendations. Single selling. In other words, don't put Epstein in there alone anymore. Somebody else like him. Cellmate assignments. When he was first placed in there, somebody else got put in there with him, so they got some recommendations about that. We've got some recommendations about the documentation, accuracy, a lot more redactions, as you can see. Officer so-and-so was responsible for observing Epstein and documenting his behavior. Officer blank mistakenly used a suicide watch logbook intended for an inmate, where he should have been using a different book. Reviewing more records here, telephone calls. He was on direct observation about when he was on suicide watch. He was denied bail on Thursday, July 18th. This was a significant disappointment for Epstein and likely challenged his ability and willingness to adapt to incarceration. Given the impact of the decision, a psychologist should have assessed his mental status after that. Epstein reportedly was in court. So really, really long document. Sentry quarters. We have the attorney logbooks. 4 logbooks were secured following his death. Post orders, staffing, sex offense, risk behaviors. Okay, so that's the rest of that. The denial of bail was a significant disappointment. We saw that. We have a suicide watch observation log. So this came over from an officer. 1:15. Epstein is still with attorneys. Still 15 minutes later, he's still with attorneys. 15 minutes later, legal. Talking about math, talking about finance, talking about the prison, talking about the environment, talking about the scene, talking about science, now finance, legal. Okay, so they're just keeping tabs on him. But apparently they missed a pretty key 15-minute interval there. Pretty big one. He was removed from suicide watch after 31 hours. Reiterated complaints about his running toilet. Thought that he might have autism, noting that Dustin Hoffman's autistic character in Rain Man had an aversion to noise, just like him. Federal marshals escorted him out of a July 31st court hearing, returned with a prison custody alert notice, says that Epstein might have, quote, suicidal tendencies. Psychologist met with him, said suicide watch not warranted. Of course, he's dead. We have this sign. Among the documents that the Times obtained was an undated sign, orange paper. It read, mandatory rounds must be conducted every 30 minutes on Epstein, as per God. Number 763180454. The word mandatory is misspelled and it's underlined in pen, and then it has a question mark written on it. The records offered no explanation of the sign. Bureau officials declined to answer any questions about it. So it's like mandatory. Like, is that a suggestion? Is this sign an order or a suggestion? Mandatory rounds. And it's not even mandatory. It's mandatory. Mandatory rounds. As per God. So it could be people just goofing around, but a very important defendant is now dead as a result of the goofing. The last day, when he arrived back on July 31st, he was given a cellmate, transferred out of there. The materials revealed highly disturbing images of the sex trafficking ring. All right, so very, very long article. I'd encourage you to read the whole thing. This is Mr. Epstein in 2014. This is his girlfriend, Karina Shuliak. Apparently, he called her from jail the night of the suicide, so you can see them together. She's one of the largest beneficiaries of several trusts that Epstein set up over the years. After finishing the call, Epstein returned to his cell where he was alone because no new cellmate had been assigned yet. He was also left unmonitored by two officers on duty, whom prosecutors later accused of spending their time surfing the internet and appearing to be asleep. This May, the two officers entered into a deferred prosecution agreement on charges that they had falsified jail records about Mr. Epstein. So those two guards, a deferred prosecution agreement is like, look, you're in trouble, we busted you, but if you don't do it again, and you're good for 16 months or 18 months or 2 years or 5 years or whatever it is, we are not going to continue to prosecute you. We're going to defer prosecution. We're going to pause it. We're going to make sure that you're good. We're going to revisit this in 2 years. And if you have been a good person, we're going to dismiss those charges. So nothing's going to happen to those guys, I'm going to guess. That's just a quick read on that. 6:30 the next morning, he found with a bed sheet tied around his neck like a noose, pronounced dead an hour later. About 2 months after Epstein's death, inmate who appeared to have worked in the kitchen emailed the psychology department about a conversation he had with the man whose cell had been next to Epstein's. He said the other inmate told him, Jeffrey Epstein definitely killed himself. Any conspiracy theories to the contrary are ridiculous. The man heard Epstein tearing up his sheet before committing suicide, the kitchen worker wrote. He wanted to kill himself and he seized the opportunity when it was available, such as life or death. In this case, which could be true. Absolutely could be true. Or he could be on an island in a beach, on a beach in an island somewhere. We also have, this is a request to staff. This is that email that I just referenced. I just spoke with an inmate who came out of SHU last night. Room was directly next to Epstein's. Anxious to describe the night of his neighbor's death. Epstein definitely killed himself, he said. Any conspiracies are nuts. Actually heard him tearing it up. I asked him if he had been extraordinarily noisy and uncivilized in the prelude to Jeffrey killing himself. His responded was in the negative, effectively refuting my theory that Epstein couldn't take the animals and chose to end it as a result. So in other words, this guy was thinking that maybe it was just so noisy that Epstein was constantly complaining about the noise, and it just got to be too much one night. He just decided, enough already. So he asks him, was it really noisy that night? Is that why he did it? No, it wasn't. I no longer believe that rooming with Jeffrey would have saved him. He wanted to kill himself and seized the opportunity when it was available. when his bunkie moved out, such as life or death in this case. Friday is my home confinement date, and clearly the staff hasn't done its job, although the law specifically states that they're required to let... All right, so now he's complaining about some personal stuff. So very interesting. Epstein documents show maybe he wasn't really intending to kill himself, but maybe that was all part of the plot. Maybe that was just sort of to convince people to take him off suicide watch, get rid of his bunk person. Very smart, very charming, very charismatic guy. That's how he got his fortune in the first place. So maybe he was just manipulating all these people so that he could, in fact, kill himself. Or maybe somebody else killed him, or maybe he's back on his island somewhere in the Caribbean. We have also random news from Disclosed TV, and this was posted back on November 13th, but a lot of interesting things are now bubbling up, which is maybe why a lot of this trial is not being covered particularly in depth. It says, just in, ex-Barclays CEO Jess Staley exchanged 1,200 emails with Epstein that included unexplained phrases like Snow White. That was over from the Financial Times. Jess Staley resigned from his position at Barclays earlier this month after a dispute with British financial regulators over how he described his ties with Epstein. What is a Snow White? Well, it's a Walt Disney female character that was 7 years old when the evil queen tried to kill her. So why is Jeffrey Epstein and ex-Barclays CEO Jess Staley talking about Snow White? That's weird. Isn't it weird? Yeah, it's a little bit weird. We have the final diagnoses from the report of the autopsy. Maxwell Trial Tracker over on Twitter is a really good follow. They're covering this stuff. They've got a lot of these documents. They posted this on the 25th. Final diagnoses, report of the autopsy. Hanging, ligature furrow of the neck. We've got different hemorrhages. We've got plethora of face and head hemorrhages of the face, fractures of the cartilage, abrasions of the mouth after the resuscitation was attempted, left forearm abrasions, hypertension, remote fracture of the right first rib. Very interesting things going on around here. Cutaneous contusions of the wrists. We've got subcutaneous hemorrhage of the left deltoid muscle. Cardiovascular disease, not so good. Confluent hemorrhages of the right bulbar conjunctiva. Right, and that's sort of in your... A lot of that I think you're going to expect when you are being hung. Here's Jeffrey Epstein. Once again, from the Tracker trial, says the circumstances surrounding Jeffrey Epstein being put on suicide watch after an alleged attempt to take his own life are in dispute. He told his lawyers he didn't try to kill himself. He was attacked.
Dean was direct.
All right. So, yeah. They kind of botched that one, didn't they? Now, another interesting story came out from The Sun back on November 20th. Says that Epstein and Maxwell both visited the Pope, which is wild. The Pope, the pedo, and the pimp, according to The Sun, beaming Jeffrey Epstein and Ghislaine Maxwell, blessed by the Pope, showing their all-powerful connections. The snap sees the billionaire and the alleged madam enjoy a private audience with the head of the Catholic Church at the Vatican. Oh, boy. Now, Maxwell's brother is also out there, and he's very upset about this. Says the brother of the socialite is charged with helping Epstein exploit underage girls. Says her prosecution is the most overhyped trial of the century, designed to break a woman targeted by the authorities desperate to blame someone for Epstein's crimes. Ghislaine Maxwell continues to have the backing of her family. Ian, her brother, said in an interview ahead of the trial, this is the most overhyped trial in a century. She will not be broken. She believes completely in her innocence, and she's going to give the best account that she can. Prosecutors say she groomed girls as young as 14 years old, been in custody for almost 17 months, and Judge Alison Nathan has denied requests for bail. So that's the update on Ghislaine Maxwell. Trial is starting November 29th, and we're, of course, going to dig into it. Not going to be broadcast, not going to be anything that we can get, any audio recordings. We're going to have minute entries, New York Times reports, and we're probably going to have some pretty bad sketches because they can't even draw people who look like the people that they are. Blurred out sketches. But we're going to continue to do what we can and follow along on the Maxwell trial. Let's see if you have anything to say about this from our friends over at watchingthewatchers.locals.com. And then it's looking like it's going to be a little bit of a shorter show today because we had a lot of reading to get through. Georgia Peaches says, hey, Rob, redacted, you had a great redacted show. Great show. That's hilarious, but I'm upset about that because it's so damn frustrating, but it's hilarious. All right, so redactions in the comments. We got Brendan says, why can't Epstein have just checked his victims' IDs? That would have solved a whole lot of problems, wouldn't it? Just check their IDs. Simple. Kincaid says, hello, Rob. I hope that all went well for you and yours. It seems relatively ignorant to the case if experts are not allowed in regardless of the side. The reason I say this is because of the evolving sociological definitions of normal. To ensure that truths do rend confusion from the facts, multiple perspectives must be considered. I think an unflinching, direct approach is needed. The insidious tendrils appear to go deep, even stately, perhaps. Yeah, this is a very interesting case for that reason. And, you know, you see a lot of ways this can go. Jeffrey Epstein, I just showed you a picture of him with the Pope. We've seen him with Bill Gates. We've seen him with Democrats, Republicans. Thunder7 says, they removed his cellmate shortly before his death. The prison cameras were conveniently not working. Guards did not do their hourly checks. Too many coincidences to be anything but a planned event. His own lawyers state that he was in good spirits that day. Yeah, and he was pretty consistent about it. And I think guys like Epstein, they truly believe that they're above the law. And in many cases, they are. So he probably thought that he was going to get out. Monster1 says, damn, Rob, didn't know you were doing a show. I was watching Ricada and missed the start. I hope you can forgive my betrayal. This one time, Monster1. This once. Don't let it happen again. Monster1 says, every redaction says Epstein didn't kill himself, which is true. It probably has his address and where he's parading around on his yacht. 3 Girly says, I watched inmates on constant watch, not fun. I've also seen those inmates go and lie to the psychologist just to get out of constant watch. We were always told that it takes less than 3 minutes for an inmate to kill himself. We were required to do 30-minute staggered rounds. As long as we were doing our watches appropriately, we would not be held responsible for an inmate that killed themselves. And if an inmate was found dead and we weren't doing our watches, we would be charged criminally, or could be charged. The COs that were supposed to be watching Epstein's were not doing their rounds correctly. They were charged with falsifying records. This is not to say that I believe Epstein killed himself, but he would not be the first inmate that would lie to a psychologist to get off of constant watch. Yeah, I think that's also a very possible explanation. And he was sharp, and I think he was pretty convincing, and he could probably convince people to get off there. Roybot says, I guess you answered my question there. Stole all that money from someone else and used that as capital as a financier. Yeah, use that and parlayed that. Turn, 40 million into 4 billion or whatever. Kincaid says, this guy's mindset suggests that he's an immoral opportunist, a talented manipulator, and the perfect middleman for big fish. I would guess he lived and breathed the life and saw the rich at their worst. This is why I say, let all the bells be rung and the tolls paid. To reach the bottom, Manly will get real F dirty. The motives of those involved must be honestly shown to the rest of us to see our rulers for what they are. I like that, Kincaid. Hopefully we do get to see some stuff out of this one. Georgia Peaches says, silly, but if Epstein actually willed something to someone entirely innocent, if there is such a thing, would they be able to eventually get it paid from his estate, or does the government keep it all? Well, I mean, he's got estates and he's got trusts and he's got all sorts of different things. I don't know that the government has been able to seize all of his assets. They're paying out. I mean, they just paid out $125 million to 150 claimants. So yeah, I mean, there's a lot of money there. And I think that he's got enough of the legal entities and funds that are surviving beyond his death. So the money will still be organized accordingly. Monster1 says, sure, the neighbor's statement sounds like something an inmate would write and not a federal agent. Yeah, the prison cell neighbor. Couldn't see anything, but I could hear him as he was shredding the bed sheets to concoct rope to hang himself with. I could hear him humming, sort of a hymn like, oh, going to kill myself tonight. Da, 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 da. And he was tearing new things. Absolutely was like having a good time over there. And he just did it. Don't have to worry about it. I'm definitely not an FBI agent. Don't worry about it. Monster1 says, FYI, everything in prison is optional when it comes to employees. Even if it was an actual note that said mandatory, it would be viewed as a suggestion. And that's from Monster1. And over on YouTube, Jacob says, so the New York Times is joining the chorus that has been saying for a while that Epstein didn't kill himself. Everybody is correcting the record, aren't they? And so that, my friends, is it for the questions that came in on the day. Short show. I know it's a Black Friday. Everybody's out there, hopefully, doing your shopping, your Amazoning, or your Audibling. I got like 7 notifications on my phone, 50%, 60%. Crypto markets, 60%. Stock markets, feels like 60%. So it's a discount everywhere. And we'll leave it at that, my friends. So I want to thank you for being a part of the show. Before we wrap up and get out of here, I want to welcome some new people who joined the community. Also, on Saturday, December 11th, we've got our monthly locals meetup taking place at watchingthewatchers.locals.com. We do it over Zoom. This month, Ugly Sweater Edition. And oh man, is it going to be a lot of fun. So I hope you can come and join us Saturday, December 11th from 7 to 8 p.m. Big welcomes to Aldo the Apache. We've got Carrie C, Gino Scrajab. We've got Rugger Bugger, Jay Markey, Cat Knees, Brody Son, Squirrel 0050, P Palin, Redbeard, Monique Nicole, Dr. Facebook Law, Hobo Jim Mombino, WV Ridge Rider. We've got Mayhem Studios, Ben Tomlinson, Laurel Unsheathed, Tucker Greb, Tommy Nukes, Phantasmagloria, Black Cat Meow, Nick McLeod, Dr. Brenton T. Blakemore, Patriot Minute, Chris C., Dr. Sammy D, Pub Crawl, Julie, Fluffles, Woods 08, Karaoke Princess, Not the Great, Cora Coco, Overton, Transparency, Miss Sinlin, Desert Pirate, BJR, J-Bot, DC Jen, David Orndorff, Drew Johan, Nice T, Miles Breeden, Time Lord Stu, Tester 22T, OGR All, and Coronas Adair. And that, my friends, is it for us for the day. I want to thank you for joining us. It was a very lovely Thanksgiving. I hope everybody had a tremendous time with their friends and family. I drove down to Tucson with my brother Joey and then drove back up with my aunt. And so I got to spend some good time with some family in the car ride for 2 hours down, 2 hours back up. And of course, all the time over the turkey and the mashed potatoes. And somebody brought lima beans, It's like, I like green vegetables, but those are really pushing it. So I hope everybody had a really amazing time with your friends and family. I'm going to be around most of the weekend. We may do some locals streams just exclusively over there. There's kind of a lull in some of the criminal trials other than Maxwell, and we can't really talk much about Maxwell. So most of the Maxwell updates are going to be as pre-recorded videos that come out daily that are just docket updates, so that those of you who don't want to join the show and hear me reading for an hour can just kind of skip over that. And so I'm curious as to, what you think is interesting. We're going to have a whole new week next week. We have a new variant out there, new scariant to come out there right around the holidays and Christmas time. So there's going to be a lot to talk about. We want you to be a part of it. So come check us out at watchingthewatchers.locals.com. Otherwise, my friends, hopefully you have some fun stuff on the agenda for this very long weekend, and it's time to get back to it. So I'll let you go do that. Have a tremendous evening. Sleep very well. And I'll see you right back here on Monday. Until then, my friends, bye-bye.